324.1 describe the lawful ownership and use of a weapon or firearm. Under Chapter 790 of the Florida State Statutes, individuals 21 years of age or older may lawfully own and possess firearms in Florida. A person younger than 21 may not purchase or transfer ownership of a firearm from a licensed importer, manufacturer, or dealer, according to Statute 790, Section 065, subsection 13 of the Florida State Statutes. Though they may lawfully own or possess a firearm given as a gift or obtained by private transaction. Licensed dealer purchase restrictions do not apply to rifles or shotguns bought by law enforcement officers, correctional officers, or military service members. Following McDaniels v. State, individuals lawfully in possession of a firearm may openly carry it in public places, unless specifically prohibited by statute. Thus, open carry by individuals 18 to 20 is not prohibited and cannot be treated as unlawful solely based on age. 324.2 describe the basic legal requirements to carry a concealed weapon or firearm in Florida. Effective July 1st, 2023, Florida allows the carry of a concealed weapon or concealed firearm without a license if certain conditions are met. The weapon must be completely concealed from the ordinary sight of another person, such as in a hidden holster, bag, purse, or backpack. A brief, unintentional, open display of a firearm by an authorized person is not an open carry violation. However, possession remains strictly prohibited for both licensed and unlicensed individuals in specific locations under Statute 790, Section 06, subsection 12A. Florida statutes, including places of nuisance, police, sheriff, HHP stations, detention facilities, jails, courthouses, courtrooms, polling places, government meetings, school, college, professional athletic events, career centers, school facilities, portions of establishments primarily devoted to dispensing alcohol, airport sterile areas, and areas barred by federal law. 324.3 determine the legality of a concealed weapon during a traffic stop. Florida allows anyone to carry a weapon or firearm on their person or in their vehicle without a license, provided it is possessed for a lawful purpose. Unlicensed individuals aged 21 or older and concealed license holders may carry a concealed weapon or firearm on their person while in a vehicle. However, unlicensed persons aged 18 to 20 must keep the firearm securely encased, example, in a glove compartment, snapped in a holster not attached to the person, or in a closed box, or not readily accessible for immediate use. Individuals are not required to volunteer that they have a weapon. However, if they have actual possession, license holders must carry and display both their license and ID upon demand. And unlicensed individuals must display valid ID upon demand. Failure to show ID is a non-criminal violation carrying a $25 fine. 324.4 explain reciprocity in the state of Florida. A non-resident may carry a concealed weapon or firearm in Florida under two distinct situations of reciprocity. Reciprocity with a license. Florida recognizes concealed weapons license issued by a non-resident's home state. However, non-resident licenses issued by a state to an individual who does not reside in that issuing state are not honored under Statute 790, Section 15, subsection 1b of the Florida State Statutes. Reciprocity without a license. Under House Bill 543, a non-resident may carry a concealed weapon or firearm without a license if they are a resident of the United States, are 21 years of age or older, and are not otherwise prohibited from firearm possession under Florida or federal law. Active service members and honorably discharged veterans 18 to 20 are also granted this unlicensed privilege. 324.5. Explain the temporary restrictions permitted under risk protection orders. A risk protection order, otherwise known as an RPO, is a court order that temporarily restricts a person's access to firearms and ammunition for up to 1 year if they pose a significant danger to themselves or others. The sworn petition must include an affidavit detailing the specific facts creating a reasonable fear of dangerous acts. Identify the quantities and locations of all firearms, ammunition controlled by the person, and note any existing risk protection orders, otherwise known as RPOs. Upon service of an RPO, the individual is legally required to immediately surrender all firearms, ammunition, and any concealed weapons license to law enforcement. 325.1. Describe the role of an arrest warrant after deciding to make an arrest. An arrest warrant provides the formal legal authority and mandate for an officer to take a suspect into physical custody. Once a judge signs a warrant based on a finding of probable cause, it authorizes any law enforcement officer in the state to track, locate, and apprehend the individual named in the document to ensure they answer for the criminal charges in court. 325.2. List situations where officers can legally conduct a warrantless arrest. An officer can legally conduct a physical arrest without a warrant under 3 primary frameworks. The first one is the officer witnesses a felony or misdemeanor offense committed in their direct presence. The second, the officer has probable cause to believe the suspect committed a felony offense, even if it occurred outside their presence. The third, the offense is a misdemeanor that occurred outside the officer's presence, but fails under a specific statutory exception allowing warrantless arrest. 325.3. List the statutory exceptions to the misdemeanor arrest requirement. An officer may make a physical arrest for a misdemeanor committed outside their presence if there is probable cause to believe the suspect committed any of the following offenses: carrying a concealed weapon, domestic violence, violations of an injunction for protection, retail, farm, or transit theft, battery, including simple battery, stalking, cyber stalking, criminal mischief, vandalism, trespass on school property, possession of cannabis under 20 grams, traffic offenses including DUI or leaving the scene of an accident, or violation of a safety zone. 325.4. Explain when you may or may not issue a notice to appear. An officer may issue a written notice to appear, otherwise known as an NTA, instead of making a physical arrest for a misdemeanor or municipal ordinance violation, unless any of the following disqualifying conditions exist. The accused fails or refuses to sufficiently identify themselves. The accused refuses to sign the NTA. The officer has reason to believe the accused poses an immediate danger to themselves or others. The accused has no ties to the community, or there is a substantial risk they will fail to appear. The accused has a known history of failing to appear for court proceedings. The officer suspects the accused may be wanted for another offense. 325.5. Explain the role of the probable cause affidavit. A probable cause affidavit serves as the formal legal document outlining the essential facts, evidence, and circumstances that justified a physical arrest or search. It is written under oath by the arresting officer and submitted to a judge to confirm that the officer possessed sufficient probable cause to support the detention, serving as the foundational document for the defendant's first appearance hearing and subsequent prosecution.